Good evening, everyone. I am Janice Mathis, Executive Director of the National Council of Negro Women. Welcome to our Women's Empowerment Program. And tonight we're doing our annual estate planning webinar. We hope that you enjoy it. In just a moment, I will come back and introduce our guest who will present along with me this evening. She's a dear friend. But right now, I'd like to ask Mr. Johannes or Ms. Allen to come in and give us some instructions on how to use this GoToWebinar platform.
Good evening, everyone. If you are on this platform on the computer, you will see a menu to your right. If you are on a device like a tablet, Surface, or iPad, you will see the menu on the top. There's a couple of things. There are two handouts. One is more NCNW webinar information, and the other is a copy of the presentation so that you don't have to take notes. You can download those and have the information, or you can enjoy the conversation between the ladies. Also, if you'd like to ask a question on that same tab, there is a questions tab that you can type in. In the interest of brevity, please do not put more than just a question, and we can continue forward. Thank you.
Thank you, Mr. Johannes. We appreciate what you and Ms. Allen do to make these presentations possible. Every year, usually in January or February, we present some information about estate planning. January and February are those times of the year when people take stock of where they are and decide to make some improvements. And one of those things that we often do is review our estate plan. I want to start tonight with one basic caveat, and that is what we offer here tonight is for informational purposes only. When it's time for you to make your estate plan, we encourage you to seek out the attorney or other provider of your choice in order to get personalized professional advice and information. It gives me a great deal of pleasure tonight to introduce a friend, Ms. Sherry Jackson. She is a lawyer with a lot of experience. She's also an entrepreneur. At one point, she ran a practice that included elder law, where she regularly gave advice to families about how to take care of the matters that we will all must face. Ms. Sherry Jackson is from Athens, Georgia, where she still lives and operates a business, and we welcome her this evening.
Thank you.
You're welcome. Thank you. We appreciate your being here. Tonight, we're going to cover some basic aspects of estate planning, like the will, what some of the probate procedures are, what intestacy is, how to avoid probate, who your heirs and beneficiaries might be, and talk a little bit about the living trust, plan giving, and give you some additional resources that you can consult in order to create your own personalized estate plan. We will explain some of the few basic procedures associated with it, such as wills, probate, and we hope to alert you to issues that you should consider as you make your plans for your own estate. Ms. Jackson, if you would, I think I'll toss it to you now, and you can give us some information about some of the basic considerations that a family or individual should make.
Okay. So some of the basic considerations you might want to embark on in your estate planning process would be whether or not you need a will. A will is a document that legally declares your wishes and disposes of your property after death. Or whether you want to go intestate succession, which means that you don't leave a will, you just let the laws of the state give your property to however their succession applies. And then you have the trust, which is a document where the owner transfers their property to a trust for the benefit of others. And we also have what's known as a reverse mortgage, which is technically a loan that seniors are allowed to get towards the equity in their house. They get to access some of the equity in their house so that they can utilize the money and they don't have to pay it back. It does have to be paid back at some point in the future, but not necessarily during your lifetime. Then there's the power of attorney, which is a document that grants authority to another person to act on your behalf. You have the health care power of attorney, which is also a document that allows a person to act on your behalf for health care decisions. And the living will does that as well, but you have to have a terminal illness in order for a living will to apply. And then consider your financial condition. You need to know, how much assets do you have? Do you have anything worth developing or paying a lot of money to do for a will or whatever? If you have any assets, or if you have a lot of assets or tax consequences, you want to consider those. But those are some of the things you should consider when you're developing your estate plan. So is this one mine too? Well, yes, it is. So why estate planning is important? You want to make sure that your property goes to the person that you want to go to. The laws of the various states, if you don't leave a will, they will decide where your money goes. And it may not go to where you want it to go. You want to limit your tax liability. So if you can structure your estate so that you minimize the tax liability, that's what you want to do. And you want to save your heirs from having troubles and heartaches and fussing and fighting and paying a lawyer to fight over certain things. And you also want to preserve your estate. You don't want creditors to take it. You don't want it to be subject to just go to waste. So those are some of the things. That's why it's important to go ahead and make pre-planning decisions. So creating a thoughtful estate plan is one of the greatest gifts anyone can leave their loved ones. It is important to update your wills when major changes occur. That is the birth of a child, marriage, divorce, if you start a business, close a business, you change, if you sell your house, if you buy a house, or the birth or the death of an heir. Those are some major factors you need to consider. Is that one yours, Janice?
Yes, I'll take it.
No, okay.
I think that is what can estate planning do for us? It can provide resources for your family, either your immediate or extended family. Think about your children, your spouse, brothers and sisters, or it can get property to the beneficiaries quickly. Often if you go to the bank or go to the tax office for real estate and you wonder, well, how do I change the name on this property or this account? You'll realize that you have to go through some type of estate process in order to make that change of ownership. Estate planning can help you plan for incapacity. If there's anyone in the family, say, who has Alzheimer's or any other illness or disability, it can help you minimize expenses. And then you get to choose who manages your estate. Who will your executor, if you have a will, or your trustee, if there's a trust. You can make arrangements to donate to a favorite cause, such as your church or sorority. And you can reduce certain kinds of taxes. And of course, you can make sure that there's a plan to continue operation of your business. These are some of the positive aspects that you can expect to derive from a sound estate plan. Excuse me. Things you need to know before you become a widow, and that's a little tongue in cheek. We're certainly not hoping that anyone becomes a widow, but these are some of the questions that you need to ask yourself and your spouse. These are things, basic items about your property and assets and debt that you need to be aware of. Is there life insurance? If so, how much is there? And what is the name of the company? And what is the policy number? Who are the beneficiaries? Where are the bank, brokerage, and retirement accounts? Is there a safety deposit box? If so, where is the key? What are the addresses, phone numbers of the next of kin? Is there a lawyer that you need to consult? And where is the will or the trust located? At this point, we'll stop for just a minute. I see there are quite a number of people on the webinar to see if there are any questions that we can answer. You can raise your hand to be recognized, or you can type in your question. Mr. Johannes, if you would let us know if there are any questions, that would be great.
Yes,
this is not the only opportunity. We'll stop again.
You currently do not have any questions?
Okay, everybody's up to par and they know exactly what we're talking about. That is great. The last will and testament is one of the most important elements of estate planning. That seems obvious on its face, but not everyone has a will and not everyone needs a will. But for most people, a basic will is an important element. Exactly what is a will? I always think about the Lord's Prayer, not my will, but thine be done. A will is one of the ways to assure that what you want done is done after your demise. It's a primary document that should be prepared, of course, while you are living, but it only takes effect at death. It's a written document generally, although there are some situations where an oral will could be recognized, but almost no lawyer would recommend that as a substitute. And it's basically a plan to distribute your assets. And it's important to remember, it's also a way of making sure that people are aware of the obligations that go with the property. Generally speaking, if you inherit the property, you inherit the debt that goes with it. A person making a will must have what we call testamentary capacity. That simply means that they're what we used to say a long time ago, in their right and disposing mind. In other words, they are mentally able to know what their assets are, who their beneficiaries or devisees or the people they want to inherit, who their heirs are, and the formalities with which the will are to be executed include, generally speaking, you would have witnesses, and in some states, it must be notarized. What should the will include? Your name, of course, a plan for distribution of your real and personal assets. Real simply means real estate, and personal assets means everything other than real estate, furniture, money, cars. There's generally a provision for payment of debts. As we said earlier, if you inherit the property, you inherit the debt as well. Burial or cremation instructions can be included in a will, although it's not necessary. Most wills include the appointment of a personal representative, which another name for that is your executor or your executrix or your trustee. And sometimes we appoint guardians for minor children in wills. which leads us to the provision for the possibility of underage beneficiaries. Generally speaking, in most states, minors under the age of 18 cannot own property in their own names, must own it through the name of another person or the identity of a person who is a caretaker for that underage beneficiary. Here are additional factors to consider. Here again, and we'll come back to this a few more times, consult with a reputable lawyer experienced with estate planning. What we're doing tonight is to acquaint you with some of the basic concepts, but it's not a substitute for sitting down with the advisor of your choice. Compile an information sheet. It would be helpful to list your investments and your assets, which makes it easier for the person who's drafting the will and easier for the person who will administer your estate. Think through clear instructions, how you want your property to be administered. Should it be sold and the proceeds divided, or will you leave it outright to one person or to several? Keep your will in a safe place to ensure that it can be easily found when it's needed. And what is a safe place? It could be a safety deposit box. It could be a safe in your home. Years ago, we used to store the wills for safekeeping in the probate court in Georgia, where I was practicing law, but I don't think they do that anymore. But you don't want a fire or theft or any other calamity to make it harder for your heirs and next of kin to find the will when it's time. And people always ask, well, who should I tell my children? Not necessarily, but it's a good idea to make sure that the executor, the person who will administer the estate, knows, first of all, that there is a will and where to look to find it. One of the most important decisions you will make in creating your estate plan is deciding who that executor will be. You certainly want to discuss it with that person and get their permission beforehand, because it is a big responsibility and it carries a lot of obligations. It can be a family member, although it does not have to be. It can be a close friend or business partner, or even a trust officer at the bank. All of those persons are entitled under most state laws to charge a fee. In practice, though, you want to think beyond the legal requirements and think about the personality of the person if it's someone other than a bank trust officer. The person should be calm under pressure. It would be helpful if they have some business experience, that they are attentive to detail, and that they're financially stable. And why is that? You don't want an executor who might be tempted to interfere with the estate assets because of their own financial instability. Although there are many options to avoid making a will, because there are some processes that you can use, devices you can use to avoid probating a will, but none of them cover everything. So for most people, some sort of basic will is in order. And even if you have a trust or designate life insurance beneficiaries, a will is a safety net for anything that does not neatly capture within the other alternatives. And we'll talk more about that a little bit later. Wills can be used to disinherit. You've got 3 children. One of them has been a spendthrift and you've had to spend a lot of time and energy. And you may feel like, well, that person has sort of used up their inheritance. A will can be used to leave out someone who might otherwise be a beneficiary of your will. Sometimes there are instances that warrant that decision. Sometimes people are not capable for physical or emotional reasons of handling an inheritance. Here again, it's best to work with a probate attorney to ensure the disinheritance clause is compliant with state law. And it's important to understand that just like in our voting procedures, where voting procedures in Philadelphia are not the same, Pennsylvania not the same as they are in Florida or in California. Every state has its own probate laws. So you must be careful that not only anything that would disinherit one of your heirs, but that all provisions of your will are compliant with the law in that particular state where the property is located or where you live. What is probate? We've used that term a lot. It is simply the procedure by which a will is proven to be valid, proven to be the last will of a decedent. A decedent is simply a person who has passed away. Probate is also generically used to refer to the legal process of administering a decedent's estate. Not in every state, but in many states, you take the will to the probate court. We've already talked about the fact that the laws of each state vary. Here again, we're telling you, consult a lawyer. In some states, the fiduciary, the executor, fiduciary is simply another word for an executor or administrator, guardian, someone who has a responsibility to care for the property of another. In some states, that person must be bonded, and they must be and reports must be filed often with the court. Although those provisions can be waived in the will itself. The will can say, I excuse my executor from posting a bond or making a report or return to the court. Probate is required to settle outstanding debts, to transfer the property. It is the executor, after all, who, if there is a piece of real estate, will eventually sign something called an executor's deed or some other type of deed to make the actual legal recorded transfer of real property from the decedent to the beneficiary. How long does probate take? Well, it depends. In every state, heirs, those are the people who would inherit from you. Generally speaking, it's your spouse and children. If you don't have spouse and children, it's brothers, sisters, and parents. If you don't have brothers, sisters, or parents, generally speaking, nieces, nephews, and cousins are the next group. But in every state, those people who would inherit from you, if there were no will, are notified because they have a legal interest. If the heirs agree to the terms of the will, the probate process can usually be completed within a few months. The average time, according to one report, is 6 to 9 months. If there are creditor claims and you have to go through a process, your executor goes through a process to determine whether or not those bills that are submitted, hospital bills, final estate, funeral bills, are valid, that can prolong the probate process. But this last bullet point is the one that matters probably more than all the others, and that is when family members disagree. That disagreement, if it blossoms into an all-out legal confrontation, can make a state and the probate process extend for a year or even longer. And I think I'll stop at this point and ask Ms. Jackson if she would take us on through slide number 21.
Okay. So when a will is contested, and if your will is not drafted, precisely by an attorney that knows what they're doing, you can leave room for it to be contested. And even when it is drafted precisely as to what you want, we all have family members that will feels like they didn't get their share and they may contest it. And if that occurs, then it just puts the assets of the estate in detriment. But if there is a procedure for that, and you do have to go to the probate court to do that, to see who is rightfully entitled to the property. So contesting it can be very detrimental, especially if it's a small estate, because the lawyers could end up with all the money in the estate, or either the bank can end up taking the assets of the estate. So you want to make sure that everything is drafted the way you want it, consulting an attorney to make sure that your desires will be met when you're doing your will, to lessen the chance of contesting the will. So intestacy and intestate succession. Estates with a valid will are referred to as testate estates, and those without a will are considered intestate estates. So it's just two ways for you to go. One is you have a will, and the other way is if you don't have a will. Those testate estates normally pass through probate much quicker than intestate. The time, if you have a will, you know, you got your will, you file it, serve everybody, and then it usually goes smoothly. If there is no will, nobody's sure how you want your items distributed, it goes according to whatever the state laws are. A lot of people won't like that, especially if you got some family dynamics involved where you got daddy in California with a new wife and he left property to children in Georgia. You have some issues. And so those are things that have to be considered. Do you have to go to California and take care of things? Can you take care of them here in Georgia? So those are the kinds of things that you want to consider. And the reason why it's really important to go ahead and have some plan written so that your property can go the way that you want it to go. Okay. Yes, the children, are they mine, his, or ours? So this is what I was saying about if there is no will, then the state is going to determine who and what the children get if they're entitled to any. And because there are a lot of variations between the states, you can't say that we live in Georgia and this is the way it's going. You have to be mindful of where the property is located. And that's usually the state where you would have to probate and the laws that prevail. So this is to show you how important it is to have something in place to devise your property to your heirs. 2 years after Prince's death, his heirs had still not received a penny of his estate. And you know he has a vast estate. So state probate laws govern intestacy. And again, we said intestacy means that there is no will. So you have to just look to what the probate courts in your state say how your property will flow after your death. So when there is no will, like we said, the state probate laws prevail. And here in Georgia, we have permanent administration, which requires notice be given to all of the heirs. Sometimes you can have temporary administration, and that occurs sometimes when there's an emergency. You want to protect the assets really quickly, so you don't have time to get the word out to all of the heirs. And a judge may just say, okay, I'm going to appoint you temporarily so that you can handle this, collect it. And it may not be an heir, it may be another lawyer, a guardian ad litem that's appointed the temporary administrator. But Notice to the heirs is not required. So that's what's the main thing about the temporary administrator. Also, the family can get together. When you got a good family that's been raised right, as my grandmama says, family been raised right, then y'all all get together and say, you know, we ain't gotta have no fuss or fight. We know mama wanted the oldest sister to take care of this, and so we're gonna let her take care of it. And she just wanted us to split up everything equally. And a family can get together and decide that. And they're really they can do that if there are no debts owing on the property. Nobody's contesting. They can get together and decide amongst themselves, this is the way we want to do it. And there are probate forms that are available that will allow you to operate in that manner. You still have to give notice and make sure everything is done. Ads have to run in the paper, in the legal ads. But it's helpful to people where there is no will and they're all in agreement.
We're going to skip over Louisiana and some of these other states, Alabama. I put this in here just so you could see how the states vary from one state to the other in terms of the share that goes to family members. For example, in Alabama, if the decedent didn't leave any parents or children and no spouse, parents or children, and the spouse gets everything. But every state has its own scheme. And this is another example. It talks about Aretha Franklin's ex-husband, who, although he was no longer technically an heir because he was no longer her husband and not her next of kin, can you believe that the Queen of Soul left no will and no trust when she died, or at least it couldn't be found? She had 4 sons who were set to inherit her estate, but there were also creditors making claims on the estate. And at that time, when this slide was created, there was even a police investigation because there was an allegation that some of the assets might have been misappropriated. But the main thing we want to take from this is, no matter how much or how little you have, it's important to have some type of written plan. If you think there is any possibility, and even if you think there is not a possibility, that your next of kin won't necessarily all agree with each other. Now we want to talk a little bit about avoiding probate. Avoiding probate, I had a tax professor, he said, avoiding taxes is legal. Evading taxes is not a good idea. Avoiding probate means you use alternative methods. Evading means you try to get by and skate by without taking care of it, and that is not a good idea. But some of those alternatives include insurance. We've already talked about the intestate succession statutes in the states. We're going to touch on trusts a little bit, and annuities and retirement plans as alternatives to a part of what a will accomplish. I'm going to skip over the specific state of Maryland. This is just another example of how the state laws vary. They're similar. They all require administration. They all require that somebody be appointed to manage. They all include provision for the family, but they differ significantly from each other. We've talked about heirs being the state law that determines who your heirs are. Heirs is simply the persons who are your next of kin, and the laws determine what proportion of the assets the heir is entitled to receive. Heirs generally refer to blood relatives, including, now spouses are not blood relatives, but they are considered within the class of next of kin and blood relatives. We've talked about intestacy. That simply means that there is no will or trust. The estate is intestate. Individuals who inherit are called beneficiaries. Sometimes we call them devisees. which means they got to devise, D-E-V-I-S-E. Persons who can be named as beneficiaries on bank accounts, life insurance policies, financial portfolios. If you add someone to your bank account, then most often whatever's in that account at your death will go to that other person and not into your estate and to your heirs. Give you a quick example. You've got 3 children. Your daughter is the one who is the most responsible, and you've got 2 sons. And so you decide, just as a matter of convenience for paying the bills, you add your daughter's name to your bank account. At your death, she may share with her brothers, but she is not legally obligated to if her name is on that bank account. The same is true, generally speaking, of life insurance proceeds. I was just talking to a friend the other day, and she said, oh, I've got a death in my family. I need to take the insurance policy to the mortuary. And we think of it that way. I think especially in our community, that the purpose of the life insurance is to pay for the funeral. But life insurance is just another form of contract, and the proceeds from the life insurance belongs to the beneficiary once the condition of death is satisfied and a death certificate is produced. It does not mean, however, that those insurance proceeds are responsible to pay the debts of the estate, including the medical bills and the funeral bill. Heirs can be beneficiaries of life insurance or bank deposits, but beneficiaries don't necessarily have to be heirs. It can be a close friend. It can be a charity. It can be someone outside the family altogether. Designating beneficiaries. Beneficiaries can be designated on retirement accounts. If you have a 401k or IRA, sometimes the investment company will ask you to name a beneficiary, just like you would do on an insurance policy. When there is no designated beneficiary, then the estate would be the default beneficiary. What do I mean by that? If there is no named beneficiary, then those proceeds in that account would be distributed according to state law as if you were intestate. And we've already talked about the fact that beneficiaries are not, when you transfer those assets using one of these devices, they are not liable for debts of the estate. Bill is married to Karen and they have 3 grown children. Bill and Karen own a house in joint tenancy. That's an important term. That means that if anything should happen to Bill or Karen, the survivor, if Bill is in an accident and is killed, then Karen owns the house because she is a joint tenant. Karen is also the named beneficiary of Bill's retirement account. When Bill dies without a will, Karen automatically inherits the house because she is a joint tenant. There are other ways she could be owned it as a tenant in common, and it would not necessarily go to her unless it was willed to her. When Bill dies without a will, she inherits the house and any remaining retirement funds. Those are not intestate property. Bill also owns $300,000 worth of other property that would have passed under will, but he didn't have one. So Karen inherits $100 worth, that is 1/3 of that property, and the 3 children split the remaining $200,000 worth of Bill's intestate property. She got the part that she was named in the deed for. The rest of the $300,000 is split among the children, and as his spouse under that state's law, she takes a child share. Beneficiaries can be assigned to checking and savings account. You can fill out something called a payable on death form. Account holders can bequeath funds to as many beneficiaries as they desire, and they can change those beneficiaries as often as they like. Heirs cannot access bank accounts until they present the death certificate and usually some form of identification or letters testamentary from the court or the probate court. I want to talk for a minute about powers of attorney. A power of attorney is a document that can be used to have someone appointed to make decisions. We referred to this earlier. Someone, and that person is called your attorney, in fact. The appointment can be made immediately, or it can be made only after you're unable to make decisions on your own. There's a special kind of power of attorney called a healthcare power of attorney that allows you to make decisions about medical treatment and health arrangements. That healthcare power of attorney becomes active when a person is unable to make decisions or communicate his or her intentions. But this is the important point. The power of attorney ends with the person's death. It has no effect and no power in that power of attorney after your demise. Put your faith in a trust. That's a little bit of a joke. You may have heard of a trust. A trust is one of the ways that you can avoid some aspects of probate. It is a way of managing assets both while you are still alive and after your death. There's something called a generation skipping trust that allows you to transfer assets to your grandchildren, and your children never take title to the assets. It skips their generation and goes straight to the grandchildren. The federal tax exemption from estate tax in 2018 was $11.8 million. So this is a way to transfer. If you're fortunate enough to be in that category with millions of dollars, you can transfer up to $11.8 million. This was back in 2018 without having liability for estate tax. But you must be careful to have someone draw up that document who is thoroughly versed in the laws of that state and the federal tax laws in order to take advantage of that estate tax exemption. And of course, the estate tax exemption now for spouses is unlimited. That's not true of children, brothers and sisters, only for the spouse. A living trust is another way of avoiding probate. The trustee, which can be you if it's a living trust, generally sometimes you are your own trustee, but it's a way of thinking about the ownership. The trust becomes the owner. You become a beneficiary. You can take advantage of a trust to pay your expenses if you are disabled or incapacitated, but that trust lives on after you do, and there's a successor trustee who controls the assets and does the management. Now, that successor trustee may or may not be the beneficiary of the trust. They may or may not be the person who will receive the benefit of the trust assets. Their main job as trustee is to manage the estate. And sometimes we get a little bit confused thinking, well, I'm managing it, so I can do whatever I want to do with it. But no, you still have an obligation to take care of those persons who are named in the trust as the trust beneficiaries. The settlor, and sometimes we call them the trust maker, is the person who creates the trust. Donor, grantor, trustor, trustee, creator, trust maker are all terms that are used to refer to a person who creates a trust, and the trustee is the person who manages the trust. Trusts can be revocable, which means they can be changed anytime the trust maker wants to, or they can be made irrevocable. The one advantage of an irrevocable trust, it puts those assets beyond the reach of most creditors. But this again is one of those things that requires you to really consult with a lawyer who specializes in this field. A living trust, again, is a written document that partially substitutes for a will. Your assets are put into the trust. The assets are administered for your benefit and then transferred to the successor trustee and those beneficiaries that you name when you pass away. Living trusts have a great value, not only to avoid some aspects of probate, but a trust can be an effective tool to use during your lifetime, particularly if you're ill or there's a disability or some mental incapacity. It's also used to minimize the risk of elder financial abuse, which unfortunately is something that we see more often than we would like to see. That is, persons coming in, becoming friendly with an older person for the specific reason of taking advantage of them. But if the property is in trust, even if they can convince that older person to go with me to the bank, we're going to sign some important papers. With a trust, only the trustee can change those documents. And so there is an element of protection there. We talked about the fact that trust can be revocable or irrevocable. This is a revocable living trust, which means it's made during your lifetime. It can be changed during your lifetime. You can have more than one trustee, and you can change beneficiaries whenever you desire. The assets in your trust pass to your beneficiaries. The difference is the trust doesn't have to be probated. The trust is more like a contract. It takes effect when it is made. It continues even after your death. There is no legal requirement in most states to file it anywhere or to notify anyone or to run ads in the paper. So for that reason, trusts are considered to give you more privacy because probate court records, generally speaking, are public records. Leave a legacy. A legacy gift is a planned future donation to a charity given through a will or other form of designation. Planned giving is a way of honoring the things that you believe in, your values and your priorities. Ms. Jackson and I are both members of Delta Sigma Theta. We might decide to leave something to Delta Sigma Theta or to NCNW or to our church or some other charitable organization. This can be in the form of a trust or a bequest or an annuity. A charitable remainder trust is a particular kind of trust that is irrevocable, that generates income for you during your lifetime, and at your death, the asset goes to the charity. Think of a house that's rented out. The rent would be yours during your lifetime, and then the house itself would go to your beneficiary of that charitable remainder trust at your death. We now have an opportunity. We've gone through a lot of stuff. I'm sure there must be questions. Mr. Johannes, are there any additional questions for us this evening?
Yes, ma'am. In the interest of
All right,
time,
we'll do our best.
in the interest of time, Ms. Allen and I will tag team and go back and forth. I will start with the first question. It is, do you have to have an attorney to develop a will?
You don't have to. There's LegalZoom and all kinds of will packets you can find online. But I strongly urge you, and I want Ms. Jackson to weigh in on this. I strongly urge you, I guess we've said it a half dozen times, it's better to have a lawyer.
Yes, it's always better to get someone that's trained and specialized in the areas of probate and wills and just transferring property, so that it just lessens the errors that you can make. For example, some states, I think, as Janice said, that require 2 signatures and then a notary. and some states don't. And so you just need to be careful that if you don't want your will invalidated, that it's done properly. And so I would get somebody that's trained in that area to prepare the will. And you have people that will help you. And I know in Clark County now, we have the pop-up clinics at the courthouse. If you go there and ask them, they can assist you in developing wills now. So you have the experts there and it doesn't cost so much. So I would definitely take advantage of the free help if I couldn't afford it, but I would try not to spare expenses so much on an attorney that's trained in that area.
Since everything is done online, do we need a lawyer to make minor changes to my will, or is there a form online that can be used?
There are an abundance of forms. I would put it this way: if you choose to use a form and you make minor changes, I would still have those changes reviewed by a lawyer. Many lawyers charge by the hour. So if they're simply reviewing a document that you have edited, it may be a little less expensive than having the lawyer create it from scratch. But there is really no substitute for having eyes on. Take something as simple as you decide you have a child and you decide that you're going to add the child's name to the will. Well, you may be in a state where children can't own property, and so you have to have a guardian in addition to naming the child. Something simple like that could cause your whole estate plan to be thrown out. You've worked a lifetime for what you've accumulated. Don't let a few $100s destroy your will in that aspect. What do you think, Ms. Jackson?
I think you can also check with the legal services organizations there in every state. So if you will look up your state's legal services or elder law commissions that are also in every state, then they would be able to help you out. And if you can't afford one, but we agree. Let somebody that has some legal knowledge look at your document to make sure it's correct.
I often think that the law, we say anybody with common sense, but sometimes the law doesn't make common sense. For example, in some states, if I want to leave something to my daughter, she can't be a beneficiary under the will and a witness to the will. So I make this will on my own and I leave everything to my daughter. And then when it's time to sign it, I have my daughter come and serve as a witness. That could be contested. Something just that simple could cause your will to be thrown out and be ineffective. So the reason we keep saying consult a lawyer, because it really is important and it really could be something simple.
Also, if you have, okay, go ahead. I'm sorry.
I think
if you develop own, how do you make it legal?
Would you repeat that, please? I'm sorry, I talked over you.
If you develop a will on your own, how do you make it legal?
Well, the simplest way is to have a lawyer review it for you. But if you do it on your own, I'm not sure exactly how to answer how you make it legal. It's legal if it's properly executed. That does not mean it will withstand a contest, though. Somebody could
For
come
example,
later. Go ahead, Ms. Jackson.
For example, if let's say you're married and you don't want your spouse to have anything, so you leave everything to your children. Well, some states won't let you disinherit a spouse.
Right.
And so you just have to be careful if you want to develop it on your own. which we don't suggest. That's why we're giving you free options. You can go to legal services, they're free. And you can go to the Elder Legal Services program, they're free. And you can go to your courthouse and see if they have some support people there to help you to see if your document is worded correctly and it has the proper signatories.
If a person is unable to make their own decisions, is it possible to become their POA?
No. Once a person is unable to make their own decisions because of a illness or disability, then they don't have what we call the capacity to make a power of attorney. And then the alternative in that case would be a fairly elaborate procedure to appoint a guardian. And that requires going into court generally and having a doctor's certificate and notice to heirs and interested persons, and it can get pretty complicated. But once you lose that capacity, and I have seen that many times, once you lose that capacity, unless it's an illness that gets better suddenly, then you can regain capacity. But if you don't have the mental capacity to understand what your property is and who you want to give it to, if you can't understand what you're doing, you can't make a power of attorney.
Or a will.
Or will, for that matter. And a lot of contests come out of that question of capacity.
What is ad infinitum?
It's
on and on and on. On and on and on. You know,
Forever.
you're second cousin them. Go ahead.
You know, people talk about if you don't make a will, your property will go to the state. That's not exactly true, because most states will give you a lot of time and your heirs never run out. If you don't have a spouse and children, maybe you got brothers and sisters. If you don't have brothers and sisters, you got nieces and nephews. If you don't have nieces and nephews, you got cousins. If you don't have first cousins, you got second cousins, third cousins, 10th cousins twice removed. There's always generally somebody who's kin to you. Now, what you do run into is you can't find them. You hadn't seen Uncle Tommy in 35 years and you don't know where he's living or whether he's even still alive or not. That can create problems for an estate. And the way you get around it is you go to his last known address, run an ad in the paper, and it depends on the state how long you have to run the ad and what the ad has to say. But you've got to make a good faith effort to find those missing heirs.
Okay.
Do we have any others?
Oh, yes. What is a survivorship?
We talked about survivorship a little bit when we talked about joint tenancy.
Okay.
Sometimes you say you're a joint tenant with right of survivorship. In other words, we own the property together in such a way that it will go to whichever one survives the other. That's a very specialized form of ownership. It is not the norm, but it does exist. What would you add to that, Ms. Jackson?
In Georgia, it's only applicable to spouses, I believe, joint tenants with right of survivorship.
Mm-hmm.
Otherwise, you could have a joint tenancy, but it wouldn't have the right of survivorship, or you could have as tenants in common. But it's a good way if spouses are going to buy a house and they put all of their money into it. They can designate so that they don't have to go through probate, that the house would go to the surviving spouse.
And if that marriage should fail and there be a divorce, you would want to make sure as you go through the divorce that you also make sure that you change that form of ownership, because you wouldn't want to divorce somebody and then they end up owning the house. because that is contractual and it doesn't necessarily change unless it's brought to the attention of the court that's presiding over the divorce. Do we have any other questions?
Certainly. Is there a place where a will can be stored online electronically?
It can be stored online. I guess you could put it in any computer file, but then what legal effect does it have, I guess, is my question. I'm not aware of one. Are you, Ms. Jackson?
I'm not aware of storing it online because it has to have the original signatures. I mean, and if you pull it down, it's not going to have the original signatures. So it has to be the paper document, and you can just store them in a safe deposit box. Or I'm not sure about storing at the courthouse anymore. I haven't tried to store it, and I don't like storing it at with the court, the probate court.
I think they stopped doing that in Georgia. I think they stopped. I believe they did. Yeah. But you know the thing about it, I think you can probate a copy sometimes, but the process you have to go through, you got to have an affidavit saying that you look for it and you can't find it, and it really does exist. It is that would be a hassle.
In PG County, you should register the will with the registrar. Is that the same in Virginia and DC?
I don't know. I have never practiced law in any of those states, not Maryland, DC, or Virginia. So I would not say. That's a good question to ask a lawyer who practices in that state and is expert in that area.
Yes.
What do you recommend for people who have no heirs? Can it be left to friends or charity?
The short answer is yes.
Yes.
And when you say you have no heirs, that means you have no cousins, no distant relatives, nobody who is related to you. Because in most states, there will be somebody. Now, you don't have to leave your property to your heirs at all. But you do have to make sure that the documents that are created to avoid leaving it to your heirs or to leave it to someone else meets all the requirements of that state's law. But most everybody's got some distant relative. You may not know them. You may have to go try to figure, well, it wouldn't be you because it would be after your death. But there's nothing that requires you to leave it to your next of kin or your blood relatives, except in some states you can't disinherit a spouse. They're gonna get a minimum share no matter what you put in the will.
How long does it take to obtain a power of attorney?
Depending on the workload of the person who prepares it for you. Generally, a power of attorney is not a very complex document. Can be done in a few hours' time. But then you've got their scheduling that doesn't have much to do with the complexity. It's just like going to the hairdresser. It might take them an hour to do your hair, but there might be 5 people in front of you.
On page 14, on slide 14, you had a list of basic assets that can serve. Can that serve as a checklist to avoid starting from scratch?
It's not comprehensive, but it offers a place to start. Things that you need to know and consider before you make your will.
Oh, okay.
I would go back to that.
There are lots of things that you need to consider that are unique to you. If you have a child who has some health issues, if you have a child that is not of and doesn't have the ability to comprehend, or if you just have, you know, weird things going on with you. You got a scamming kind of husband, you got a child that has cheated everything out of, you know, has scammed grandma out of her money and trying to scam you. Those are some things that are unique that you might want to consider when you're deciding how to distribute your assets.
And every situation is unique. Every family. And I think pay special attention if there've been more than one marriage. If there's more than one set of children. Think carefully, you know, people maybe have children in one marriage and then they marry somebody and they've got their own children. You really got to think about through all the possibilities of which one dies first. Because if I leave everything to my children, but then I die after my spouse. Well, no, I didn't say it right. If I leave everything to my children, I die before my spouse. If my spouse dies, everything that he has might go to his children and nothing would be left for mine. You really got to think through those nuances of who's the first to die. And then what happens if you die in an airplane crash or something where you can't tell which one died first? There are mechanisms to take care of all of that, which is why we say this is not as cut and dried as pulling something down from the internet, because your own specific family dynamics and situation will bear on how that question is resolved.
Can you decide who will get custody of your children in a will, or would that have to be handled through court?
You can name who you want to be the guardian and to take care of your children, but and usually your wishes are followed, but that's still a matter for the court to decide.
And you can't give anybody else parental rights, not in a will. By that I mean, you can say, I've got a college savings fund and I want this person to be the administrator of it, and I want this person to be in charge of my child's property and make sure that my child gets medical treatment. But you can't use a will to terminate the parental relationship with the other parent, if that makes any sense. You can't deprive, for example, father's got visitation rights. You can't use a will to terminate the visitation rights.
Mr. Loris Huggins, we've unmuted your mic if you want to ask your question.
I'm sorry, I did not hear you.
I said, Mr. Loris Huggins, we unmuted her mic if she wants to ask her question.
Oh, okay, absolutely.
Ms. Betty Hayes, we've unmuted your mic if you want to ask your question. These are the hands that are being raised. If they have a microphone, I've been trying to get to them. Some of them don't, so we'll go back to the written questions. Do you have to pay medical bills other than debts, credit cards of your deceased parent or spouse or child?
I would say if the estate has the funds, then you're supposed to pay their debts. But if they don't have any funds, you're not liable for their debts if you're the executor of the will. Or if you're appointed, you're not liable for their debts personal.
Yeah, that's right. You're not personally liable, but if the estate has assets,
Right.
then the debt will have to be addressed. Now, not necessarily paid, because you might be able to negotiate to reduce some of the debt, but you can't, for example, go get the new Cadillac out of the driveway and forget about the fact that the bank's got a lien on the title. Just because the person died and they left you there, I leave my latest automobile to my daughter. Well, that automobile is not paid for. The person who left it owns it, but the bank also has an interest in it. So if you take the property, you take the debt. I've seen families that they were real concerned about the estate until they saw how much debt there was. And then they got less concerned about being inherited. I shouldn't say that, but it happens.
In some states, they have what is called a holographic will. How does that differ from working with a lawyer?
Holographic will means that it is, well, I'm trying to remember what holographic meant. It's something about the signature.
Is that oral? That's oral will, isn't it? Lord Jesus, you taking me back to 1L.
Yeah, take us back to property 101. Let's go to the next one and let's see if I can figure out what the answer to that is. Holographic will.
I have the definition if you want me to read it from
Yeah,
Google.
read the definition, Ms. Allen.
A holographic will is a handwritten and testator signed document and is an alternative to a will produced by a lawyer.
That's right. I knew that had something to do with the signature. If the state recognizes it, and if there are no other problems with it, I think many states do recognize a holographic will written out. And one of the, they say, well, if it's in that person's own handwriting, then we have pretty good evidence that it is genuine. That's the legal basis for it. But again, I wouldn't recommend relying on a holographic will. Suppose somebody contests whether it's your signature or not, or whether it's your handwriting. Suppose your handwriting changed over time. My handwriting today doesn't look like the handwriting I had 20 years ago.
Can a home that's still in mortgage be placed in a trust?
Can a home that's
It still has a mortgage still be placed in a trust?
It can be placed in a trust, but putting it in the trust does not absolve the trustee or the settlor from paying the mortgage. Those rights supersede the trust.
Can a trust be contested?
It can be, not as easily as a will though, but yes, a trust can be contested. And it's an interesting question because in order to contest something, you have to first know that it exists. And remember, we talked a little bit about privacy. There is no, unlike with a will in most states, and the heirs have to be notified, there's not much provision in most states, generally speaking, for notifying anyone other than the beneficiaries that a trust even exists and the trustees. So it's private in that sense, not only private from the world, but private from other family members.
Ms. Harney, do you want to ask your question, Ruby Harney? Your microphone is open. Unmute on your end.
Yes, can you hear me now?
Yes.
Yes.
Okay, I have a two-part question. The first part is, what are the general attorney fees for to develop a will or trust? And then the second part is, are there any disadvantages to having a trust or a will?
Are there any disadvantages? That's an interesting question. I can't think of any disadvantages of having a properly drawn will or trust document. In terms of fees, they vary greatly. From a few hundred to a few $1,000s is what I would estimate, depending on the complexity and size of the estate and experience of the lawyer. Generally speaking, the more experienced the lawyer is, the more they charge.
Okay, thank you.
Thank you for your question and thanks for joining us tonight.
Okay.
I believe Miss Helen Settles. Another question, I believe your mic is on. Miss Helen, okay. Well, someone would like for you all to talk more about charitable trust.
Charitable trusts are a very specific type of trust that is designed to benefit some nonprofit organization that you care about. A charitable trust has a tax identification number, which means that it is obligated to file at least an informational tax return. A charitable trust can be effective, generally speaking, at the death of the person who makes the trust, so that the assets, whatever property it is, if it's money, if it's real estate, if it's oil well, whatever the property that is in the trust generates income, that income, generally speaking, goes to the owner during their lifetime, and then the asset goes to the charitable designee at their death. And there could be more than one. We had someone who made a charitable trust gift to NCNW not too long ago, and there were, I think, 15 charities named for that one charitable trust. It took a long time for it to settle too.
Miss Andra Harris, your mic is open.
Yes, good evening. Okay, so if you're a beneficiary and the executor of a family member's estate, but the actual house is paid or there's no mortgage, but the ex-husband's name is still on the deed, how does that work if the family member passes away?
The first thing I would do is if there was a divorce, you say the ex-husband, that means that there's a divorce. Check
Yes, ma'am.
the divorce decree, which means you may have to go to the court where the divorce was granted to get a copy of the divorce decree and see if the divorce decree makes disposition, says anything about that house. They may not have gotten around to changing the deeds, or they may have made a later deed that removed his name from it. So you really need a title examination.
Okay, okay. So you're saying a title examination and then
A
get a
title,
copy of
yeah.
the divorce decree. Okay.
Check to see if the judge didn't, generally speaking, a judge won't let you out of the courtroom on a divorce until they've at least made some order, some provision about that house. Generally speaking, you're not going to get a couple that's divorced and there's not some mention of real estate in the divorce itself.
Okay. Thank you
And
so much.
see the deed. You're
Okay.
welcome.
Should a whole life insurance policy be put into the trust?
That is beyond my,
Probably not. Yes, I'm an insurance agent too. My husband too, but whole life,
What would the
it
advantage
can
be
be.
is my question.
You mean as opposed to a term life? Is the person still there?
Let's see.
I mean, you can name the estate as the beneficiary.
Yeah, and then it would pass according to what the trust terms are. But I'm trying to think, is there any advantage to doing it that way? I guess if you had several beneficiaries, or if you change beneficiaries often, putting it in a trust might make it a little bit less paperwork.
Can the administrator petition the court to control one of the beneficiaries who's 59 years of age?
Control a beneficiary who's 59 years of age.
Is there incapacitation? Is there the beneficiary incapable of taking care of their own affairs? Hmm.
I would think for it to work, there would have to be some reason why that person is not competent to manage their own assets.
Right.
Now, when you say can an administrator, you know, people can file anything they want to file. I guess the real question is, would the court grant that petition? And so I think what Ms. Jackson and I are thinking is the main reason that a judge would grant something like that is if there was evidence that the person was incapable of taking care of themselves.
Say a drug addict.
Drug addict, that would qualify.
How
But
long
now,
did
go ahead, Chair.
That wasn't me. That was someone
Oh.
else.
I don't want to give the impression that that would be a simple or easy thing to do, because it would not be unusual for that 59-year-old to contest that request to be managed by the administrator and say, I'm not a drug addict. What makes you think that? Prove that and it would be the burden of proof on the administrator to prove that the incapacity exists. And so that could be timely, and that sounds like the kind of thing that families get into and eat up a whole lot of time and money.
Mm-hmm.
Okay, we've got time for 2 more questions.
Okay.
how long does it take to go through probate if the creditors have been satisfied?
If the creditors have been satisfied and the family is satisfied, you're probably looking at about 6 months if you're diligent and work on it faithfully. If the creditors are satisfied and the family is dissatisfied, it can take years. I had some girls whose father remarried after they were young adults, and they didn't particularly like stepmom. And they argued for years about trucks and hats and watches and shoes, stuff that probably wasn't worth $10,000. But they weren't fighting about the stuff. They were fighting about hurt feelings. And lawyers who practice in this area have to be sensitive to those dynamics and those feelings, because often what they're upset about doesn't have anything to do with the property. It's got something to do with unresolved issues that were in the relationship before the person died.
Mm-hmm.
And the last question is, can you donate or will property?
Yes.
Can you donate or will property?
Yes.
Yes.
Both. You can donate it or you can will it. I want to thank everyone for being part of this session tonight. If you've got additional questions, please consult a lawyer of your choice. We hope this has been interesting and perhaps a little fun. I want to thank my good friend Sherry Jackson for being part of this and helping me with this tonight. It was a pleasure, and we look forward to seeing you again. We do these webinars every 4th Thursday night from 7 until about 8 or 8:30, and we cover a variety of topics. And if you missed one or you want to see some that we've done in the past, most of them are stored at YouTube at the NCNW channel. And of course, we hope you will consider joining the National Council of Negro Women as we celebrate 85 years of leading, advocating for, and empowering women of African descent, their families, and communities. On behalf of Dr. Janetta Betch Cole and all the board members and staff of NCNW, we wish you a good night.
Good night.